Chapter 40. Specific performance of Parol contracts, part performed. Analysis. Section 817. Rationale of the doctrine. The doctrine was settled at an early day in England, and has been fully adopted in nearly all the American states, that a verbal contract for the sale or leasing of land, or for a settlement made upon consideration of marriage, if part performed by the party seeking the remedy, may be specifically enforced by courts of equity, notwithstanding the statute of frauds. The contract must possess all the elements and features necessary to the specific enforcement of any agreement, except the written memorandum required by the statutes. Two theories are in vogue, by which this doctrine is sought to be supported. The first of these can, perhaps, be best explained by means of a summary of a judgment in a leading English case, in which it was most fully and ably, if not convincingly, expounded. It is established, both in law and equity, that the fourth section of the Statute of Frauds does not avoid parole contracts, but establishes a rule of evidence. From the law thus stated, the equitable consequences of the part performance of a parole contract concerning land seem to me naturally to result. In a suit founded on such part performance, the defendant is really charged upon the equities resulting from the acts done in execution of the contract, and not, within the meaning of the statute, upon the contract itself. When the statute says that no action is to be brought to charge any person upon a contract concerning land, it has in view the simple case in which he is charged upon the contract only, and not that in which there are equities resulting from res gesti subsequent to and arising out of the contract, so long as the connection of those res gesti with the alleged contract does not depend upon mere parole testimony, but is reasonably to be inferred from the res gesti themselves. Justice seems to require some such limitation of the scope of the statute. Where, for example, the vendee has entered into possession, parole evidence of the contract is necessary to explain and excuse that possession, but the vendor is charged, not upon the contract, but upon the equity arising from the receipt and delivery of the possession. The doctrine, however, so established has been confined by judges of the greatest authority within limits intended to prevent a recurrence of the mischief which the statute was passed to suppress. It is in general of the essence of such an act, viz., an act of part performance, that the courts shall by reason of the act itself, without knowing whether there was an agreement or not, find the parties unequivocally in a position different from that which, according to their legal rights, they would be in if there were no contract. But an act which, though in truth done in pursuance of a contract, admits of explanation without supposing a contract, is not in general admitted to constitute an act of part performance, taking the case out of the statute of frauds, as, for example, the payment of a sum of money alleged to be purchase money. The payment of a sum of money is an equivocal act, not, in itself, until the connection is established by parole testimony, indicative of a contract concerning land. Similarly, continuance in possession by a lessee after the end of his term is not in itself evidence of an agreement to renew the lease, since the act may point to a tenancy at will equally as well as to an express agreement. Such being the theory of part performance, consistent with and explaining all of the adjudged English and a majority of the American decisions, it is confessedly artificial, dicta in many of the English, and in nearly all the American, cases, place the doctrine, wholly or in part, on a broader ground. The ground is equitable fraud, not an antecedent fraud in entering into the contract, but a fraud inhering in the consequence of setting up the statute as a defense. If the defendant knowingly permits the plaintiff to do acts in part performance of the verbal agreement, acts done in reliance on the agreement, which change the relations of the parties and prevent a restoration to their former condition, it would be a virtual fraud for the defendant to interpose the statute as a defense, and thus to secure for himself the benefit of the acts of part performance, while the plaintiff would be left not only without adequate remedy at law, but also liable for damages as a trespasser. Payment in money is not a part performance, because the remedy at law is adequate for its recovery. There has been no irrevocable change of position. Payment in services, on the other hand, at least in services of such a character as not to permit a pecuniary estimate of their value, is an act of part performance. This result logically flows from the theory in question, and in this respect only, in most of the jurisdictions, Do the two theories of part performance differ in their practical results? Delivery and receipt of possession under the contract is deemed an irrevocable change of position which it would be a fraud on the vendor's part to disturb, in several jurisdictions. However, this reason, as applied to mere possession, is rejected as artificial and untrue to fact. Section 818. Doctrine does not apply at law. The doctrine of part performance is purely a creation of equity and is not recognized at law. Hence it follows that no distinctively legal action can be maintained upon an oral contract within the statute of frauds. When the vendor disposes of the property to a bona fide purchaser for value, without notice, the vendee may maintain a bill in equity to recover damages from the vendor. The jurisdiction rests upon the ground that equity alone can grant relief. Section 819. Possession alone, sufficient. The mere delivery and taking of possession in pursuance of the agreement is, by the weight of authority, sufficient part performance to warrant equity in granting relief. This is rested upon the ground that the acknowledged possession of a stranger on the land of another is not explicable, except on the supposition of an agreement, and has, therefore, constantly been received as evidence of an antecedent contract, and as sufficient to authorize an enquiry into its terms, the court regarding what has been done as a consequence of contract or tenure. The possession must be actual, notorious and exclusive, and must be taken with the consent or acquiescence of the vendor. Because of the requirement of exclusive possession, it follows that one tenant in common cannot claim a right to specific performance against his co-tenant by reason of his possession. Such possession is explicable upon the supposition of a continuance of the co-tenancy. Where a contract provides for the sale of several distinct lots for one price, probably possession of one lot is sufficient to warrant relief as to all. But this principle cannot apply, of course, when the lots are sold under separate agreements. It is to be noted that possession must be taken in pursuance of contract. Therefore, possession taken prior to the contract or possession preparatory to the contract is not sufficient. Section 820. What possession not sufficient? As possession must be taken in pursuance of a contract, a mere holding over by a tenant after the expiration of his lease is not sufficient part performance to take the case out of the statute. Where, however, there is a change in the terms of the tenancy, as, for instance, in the amount of rent paid, or where the tenant makes substantial repairs or improvements, such circumstance in connection with the possession is sufficient to warrant relief. Possession obtained wrongfully is, of course, no ground for relief, for it does not refer to any contract whatever. Section 821. Possession coupled with payment or improvements. While the weight of authority undoubtedly supports the view that possession alone is sufficient to take a case out of the operation of the statute of frauds, it will be found that in a large majority of the cases other circumstances have been present. Under the theory of the English courts, these additional circumstances are immaterial. But under the theory that there must be an irrevocable change of position, prevailing in a few of the American states, such circumstances are necessary. Even in states where possession alone is sufficient, however, it is frequently stated that possession coupled with payment of the whole or a part of the purchase price will remove the case from the operation of the statute, and this is the rule in most of the other states as well. It is also stated quite generally that possession coupled with the making of valuable improvements is sufficient part performance. It is to be noted that in the states insisting upon additional circumstances, neither payment nor the making of improvements in addition is necessarily sufficient, for even in such cases there may be no irrevocable change of position. This distinction, however, is frequently overlooked by the courts. Section 822. Suit by vendor. The doctrine of part performance is applicable not only to suits by a vendee, but has been applied to suits by a vendor as well. We have seen that a vendor is entitled to specific performance in many instances where his only claim is for money, the purchase price. It has been said that delivery of possession by the vendor and acceptance thereof by the vendee will be sufficient part performance to entitle a vendor to sue, and the case is still clearer when possession is accompanied by other acts. Section 823. Modifications and rejection of the doctrine. The rule that delivery and acceptance of possession alone are sufficient to take a case out of the statute is not accepted by all the states. In Massachusetts and Texas, fraud is the rationale of the remedy, and consequently it is held that the acts must be such that adequate compensation cannot be made except by a conveyance, so that it would be fraudulent for the vendor to refuse to execute a deed. It is clear that mere possession does not answer this requirement, and even possession coupled with payment or the making of improvements does not necessarily suffice. In Illinois, and now as a result of statute in Alabama, relief will not be given unless possession is coupled with payment of the whole or a portion of the purchase price. In Kentucky, Mississippi, North Carolina, and Tennessee, the whole doctrine of part performance has been rejected, but in several of these states, in order to prevent too great an injustice, a party who goes into possession and makes improvements upon faith of an oral contract is allowed a lien for the value of such improvements. Section 824. Payment not sufficient. It is the generally accepted doctrine that payment of the whole or a part of the purchase price is not sufficient in itself to take a case out of the operation of the statute of frauds. Several reasons are given by the courts for this rule. In the first place, it is said that only evidence which a party might use in defense to an action of trespass is admissible to show part performance, and that payment does not come within this principle. In the second place, it is said that in another clause of the statute, with respect to goods, it is provided that payment shall operate to take the case out of the statute, and the courts have therefore considered this as excluding agreements for lands, because it is to be inferred, that when the legislature said it should bind in the case of goods, and were silent as to the case of lands, they meant that it should not bind in the case of lands. Again, payment of money is not part performance, for it may be repaid, and then the parties will be just as they were before, especially if repaid with interest. Insolvency of the vendor and his consequent inability to respond in damages do not alter the rule, and it is immaterial whether such insolvency existed at the date of the contract, or occurred subsequently. Section 825. Conveyance by plaintiff not sufficient. A conveyance by a plaintiff in pursuance of an agreement for an exchange of lands is not sufficient part performance to warrant the court in granting equitable relief. While such a conveyance is referable to a contract, it is not necessarily referable to a contract for the land sought to be recovered. Part performance which takes a case out of the operation of the statute must be done or allowed by the party sought to be charged. Where, however, there is in addition an act of part performance upon the part of the defendant, as by taking possession of the property conveyed, the plaintiff may have specific performance. This rests upon the same principle as that which authorizes such relief in favor of a vendor. Where the plaintiff has made a conveyance he is not remediless, for he may maintain an action at law for the value of the property. Section 826. Whether personal services are a sufficient act of part performance. Where the consideration is paid, not in the form of money, but in the form of personal services of a character such that they do not readily admit of a pecuniary estimate or recompense, shall this be considered an act of part performance? On this question the American jurisdictions are very evenly divided. The answer must depend on the theory which is adopted as the basis of the whole doctrine. On the first theory stated in a former paragraph, payment in services no more points to a contract concerning specific land than does payment in money. In fact, in the ordinary case, domestic services by a relative or by an adopted child, the fact of the services rendered gives rise to no inference of any contract whatever. On the other hand, if equitable fraud be taken as the basis of the doctrine, and the impossibility of restoring the complainant to the situation in which he was before the contract was made, the rendering of services, for a long term of years, the value of which cannot be estimated by any pecuniary standard, must be considered an act of part performance of the highest character. The fraud upon the complainant is often greater than that resulting from either the taking of possession or the making of improvements. The promise, in these cases, has nearly always been to make a will devising land to plaintiff, the services rendered, the care of an aged or invalid relative, often coupled with an abandonment of the plaintiff's previous home or occupation, or, in a large group of cases, the entire change of situation resulting from a virtual adoption of the plaintiff, when a minor, into the promisor's family, and the discharge of the domestic duties and obligations of affection flowing from such relation. Section 827. Miscellaneous acts of part performance. While possession, and possession coupled with payment or the making of valuable improvements are the most frequent acts of part performance recognized as sufficient to warrant equitable relief. The courts have interfered in a few other instances. Thus, a dismissal of certain actions at law has been held sufficient, for the plaintiff could not be placed in statu quo. A parole agreement between CO tenants not to partition land has been enforced when the parties, in reliance upon it, have made leases of the property. A release of a dower and homestead right has been held sufficient to warrant the enforcement of a parole contract to convey other land in consideration thereof. Oral contracts for the conveyance of easements have been enforced when, in pursuance thereof, work has been done in opening windows as directed by defendant, and he has been given employment, and where a railroad has constructed its tracks and located its depot at a certain point, in pursuance of a contract to convey a right-of-way. Section 828. Oral promise to give. A parole promise by one owning lands to give the same to another will be enforced in equity, when the promisee has been induced by the promise to go into possession, and, with the knowledge of the promiser, has made comparatively large expenditures in permanent improvements upon the land. The ground of the jurisdiction is that a failure to convey after the donee has made a change of position would amount to a fraud. Equity does not ordinarily interfere to enforce voluntary agreements, but in this case the courts have construed a consideration into the agreement. In the language of a leading case, anything that may be detrimental to the promisee or beneficial to the promiser in legal estimation will constitute a good consideration for a promise. Expenditures made upon permanent improvements upon land with the knowledge of the owner, induced by his promise, made to the party making the expenditure, constitute in equity a consideration for the promise. Such a promise may be enforced against an executor or administrator, as well as against the original promiser. Where the promise is to convey if the promisee will make improvements, there is a real consideration, and relief will be readily granted. Section 829. Marriage not part performance. In cases of contracts made in consideration of marriage, it is almost universally held that marriage alone is not such part performance as will take a case out of the operation of the statute of frauds. This results from the statute itself, which requires agreements in consideration of marriage to be in writing. To hold marriage alone to be sufficient would render the statute nugatory. For, so far as the fact of marriage is concerned, such agreements are always performed before they become the subjects of judicial consideration, and no case would ever be within the statute. Marriage coupled with other acts, such as the delivery and acceptance of possession, may, however, be sufficient. In this connection a distinction should be noted between cases arising between the parties to the marriage themselves and those arising between a party to the marriage and a third person. In the former case, marriage coupled with possession is not, under the prevailing theory, sufficient, for the possession is referable to the status as husband or wife, and not necessarily to any other contract. Section 830. Specific performance because of fraud. Independent of doctrine of part performance. Independently of the doctrine of part performance, relief may be granted when the defendant has been guilty of fraud which leads to an irretrievable change of position. Accordingly, where a marriage is obtained under a fraudulent promise to convey property, the defendant may be ordered to carry out his contract, although, as we have seen, marriage is not a sufficient part performance to take a case out of the statute. Likewise, where there is a fraudulent omission to have an agreement reduced to writing, which induces an irretrievable change of position, equity will grant relief. A mere failure to fulfill a promise to have an agreement reduced to writing is not sufficient, however, in the absence of fraud.